Sarah had a dream of opening her own bakery, but she needed financial support to turn her dream into reality. She approached her local bank, which agreed to provide her with a loan to start her bakery. The bank becomes a financial creditor in this scenario. Sarah received the loan from the bank, and with the borrowed funds, she rented a bakery space, bought equipment, and hired staff. She worked hard to make her bakery a success and started generating income through her delicious pastries and cakes. However, as time passed, the business faced some challenges. The bank was entitled to recover its debts, and being a financial creditor, it can initiate a legal process called Corporate Insolvency Resolution Process to cover the outstanding debt. As per Section 5, Subsection 7 of Insolvency Bankruptcy Code, financial creditor is a person to whom a financial debt is owed and involves a person to whom such debt has been legally assigned or transferred to. This financial debt means a debt along with interest which is disbursed against the consideration for the time value of money. This includes money borrowed with an obligation to pay interest, funds obtained through acceptance of credit facilities or its dematerialized equivalent, money raised by issuing bonds, notes, debentures, loan stock or similar financial instruments, obligations related to lease or hire purchase contracts, receivables sold or discounted except those sold with no recourse for the seller, funds raised by transactions that have the similar effect as borrowing such as forward sale or purchase agreements, derivative transactions entered into to protect against or profit from changes in rates or prices. As per Section 7 of Insolvency and Bankruptcy Code, a financial creditor either by itself or along with other financial creditors can file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default occurs. Along with the application, the financial creditor has to submit the record of the default with the information utility or such other record, the name of the resolution professional proposed to act as an interim resolution professional, any other information as may be specified by the Insolvency and Bankruptcy Board. The adjudicating authority has to, within 14 days of the receipt of the application, ascertain the existence of a default. If the adjudicating authority is satisfied that a default has occurred, the financial creditor's application is complete and there is no disciplinary proceedings pending against the proposed resolution professional, it can admit the application. However, if the default has not occurred or the application is incomplete or any disciplinary proceeding is pending against the proposed resolution professional, it can reject such application. But the adjudicating authority, before rejecting the application, has to give a notice to the applicant to rectify the defect in the application within 7 days of the receipt of such notice from the adjudicating authority. The corporate insolvency resolution process is set to commence from the date of admission of the application. The adjudicating authority should communicate its order to the financial creditor or corporate debtor within 7 days of admission or rejection of the application. Hope you now understand the role of a financial creditor.